In a courtroom brimming with anticipation and national attention, Judge Amy Coney Barrett presided over a hearing involving the young, fiery, and controversial political figure, Karoline Leavitt. The proceedings were expected to be routine. Leavitt was accused of violating federal disclosure regulations, a charge she fiercely denied. Barrett, confident in her authority and backed by precedent, approached the bench with measured determination. From the outset, the tone was firm. Leavitt stood her ground, representing herself against her legal team's advice. Observers expected a quick reprimand or potential jail time, assuming Leavitt had walked into a legal trap. But as the hearing unfolded, what no one anticipated was the quiet unraveling of assumptions, and a legal counterstrike that would leave the courtroom in stunned silence. Judge Barrett opened with a direct statement about the seriousness of the charges, noting the historical implications of transparency violations. Leavitt responded with controlled defiance, quoting statutes and questioning procedural conduct in the investigation. Barrett raised an eyebrow. "Are you challenging the jurisdiction of this court?" she asked. Leavitt nodded. "I am challenging the process used to arrive here." Spectators shifted in their seats. Using precise legal terminology, Leavitt cited cases from administrative law history that suggested her rights had been bypassed in a rush to indict. Barrett attempted to redirect, but Leavitt pressed forward, forcing the court to consider whether the agency involved had exceeded its investigative scope. It was clear this was not going to be a passive defense. Barrett, both curious and cautious, allowed Leavitt to elaborate. What followed was a blistering, eloquent dissection of regulatory overreach, weaponized bureaucracy, and due process misapplication. Leavitt referenced not just federal code, but obscure appellate decisions, quoting footnotes and legal opinions with surgical accuracy. Court officers exchanged glances. The prosecution looked visibly shaken. Leavitt began to outline how her case had originated from a faulty interpretation of disclosure timelines, citing 3 Supreme Court precedents that contradicted the assumptions in her indictment. Barrett interjected with questions, clearly testing Leavitt's depth of knowledge, but each challenge was met with calm, evidence-based rebuttals. Slowly, the courtroom began to understand that Leavitt wasn't just defending herself. She was teaching the law as she fought, as Leavitt. Presented a 40-page motion she had drafted herself, Barrett carefully read sections aloud. It wasn't just articulate, it was legally airtight. It dismantled the timeline of the prosecution's argument and raised legitimate constitutional concerns about selective enforcement. Barrett, known for her command of legal philosophy, leaned forward, intrigued. "Are you suggesting that the indictment itself is a political tool?" she asked. Leavitt smiled. "I'm not suggesting it, Your Honor. I'm demonstrating it." Audible gasps echoed in the chamber. Barrett asked the prosecution for clarification on a key date, and they fumbled the answer. Leavitt seized the moment, exposing inconsistencies in discovery documents and procedural filings. Her confidence didn't just stem from defiance, it was rooted in mastery. This wasn't performance, it was legal brilliance. At this point, Barrett's demeanor shifted. What began as an authoritative push for courtroom order transformed into a reluctant admiration. She asked for a recess and reviewed Leavitt's filings in her chambers. When the court resumed, Barrett posed a challenge. "Miss Leavitt, if you were sitting in this chair, how would you rule?" Without hesitation, Leavitt walked the court through the procedural flaws, lack of evidentiary foundation, and misapplication of administrative penalties. "The law must not be used to intimidate," she concluded. "It must be used to illuminate." Barrett was silent. The prosecution remained stone-faced. Spectators began to murmur, realizing this hearing was becoming more than a trial, it was a moment. A young woman accused of defiance was redefining the rules in real time. News of the courtroom. Drama exploded on social media and news networks. Clips of Leavitt quoting constitutional law with the precision of a senior litigator went viral. Legal scholars began live-tweeting their shock and admiration. Pundits scrambled to reframe the narrative. What had started as a supposedly clear-cut case became a national referendum on legal integrity and government overreach. Journalists dubbed Leavitt the constitutional flame. and even those who previously dismissed her began acknowledging her intellect. Overnight, Leavitt wasn't just a political firebrand, she was a legal force. Meanwhile, Barrett returned to the bench with a rare look of contemplation. Aware that this moment had far-reaching implications beyond the courtroom walls, Barrett's final exchange with Leavitt was both professional and philosophical. "Miss Leavitt," she said, "whatever the outcome of this case, your argument has raised serious questions about how we interpret and enforce regulation." Leavitt responded humbly. "That's all I ever wanted, Your Honor." Barrett asked the court clerk to review the transcript and submit the constitutional challenges raised for judicial review. Then she addressed the room. "I did not expect to be confronted with such a profound legal reckoning today," she admitted. The audience erupted in applause despite courtroom decorum. Barrett did not object. For a moment, judge and defendant were not adversaries, but two minds engaged in the defense of the very institution they both served in different ways. Following the hearing, Barrett dismissed the case without prejudice pending further constitutional inquiry. It was not a declaration of innocence, but it was far from a conviction. Legal analysts were stunned. For a sitting Supreme Court justice to acknowledge procedural error at such a level was unprecedented. Even Leavitt walked out of the courtroom too, a wall of cameras declining to gloat. "I respect the court," she said, "and I'll return if asked to, but I will never stop defending the law from those who misuse it." That statement was replayed on every major news network and quoted in op-eds. Leavitt's transformation from political lightning rod to constitutional warrior was complete. And yet, she remained grounded, always pointing back to the law, not herself. Within days, legal schools reached out to invite Leavitt for lectures. Law journals requested permission to publish her motion. Students flooded forums, inspired by her calm defiance and intellectual precision. Some called it a Leavitt doctrine, the idea that ordinary citizens could challenge powerful institutions, not with protest, but with deep understanding of the systems themselves. Barrett, meanwhile, released a formal judicial memo acknowledging that the legal issues presented merit further review and demand institutional humility. It was seen as a moment of rare accountability at the highest level. The case faded. From legal threat into legal legend, what remained was the memory of one woman standing alone, dismantling an entire argument with nothing but reason and knowledge. Months later, Karoline Leavitt published a book titled Rule of Thought, chronicling the experience and calling for civic literacy as the foundation of democracy. It became a bestseller. In interviews, she spoke more about the Constitution than politics. "If people know the rules," she said, "they're harder to break." Judge Barrett, in a rare public appearance, was asked about the hearing. "That young woman," she said, "reminded me that the courtroom isn't just about power. It's about truth, no matter who wields it." Their clash, once expected to end in punishment, became instead a lesson for a generation. In the end, it wasn't about who won, it was about who understood. And in that courtroom, Leavitt understood more than anyone dared expect.